The courthouse was alive with movement, a machine that never stopped grinding. Lawyers in pressed suits hurried through the marble-floored corridors, their briefcases clutched tightly in their hands, their expressions cold and calculating. Defendants, some trembling, others defiant, waited their turn to stand before the judge, an unseen force that determined their fate with the slam of a gavel. For many, this place was a symbol of justice. For others, it was a battleground where the powerful flexed their influence, and the less fortunate hoped, often in vain, for fairness. The air was thick with murmurs, whispers of pending verdicts, last-minute legal maneuvers, and hushed speculations about today's cases. But amid the routine chaos of the courthouse, there was one case that had already captured attention before it even began. At the center of it sat Judge Ronald Whitaker, a man who had presided over this courtroom for nearly 2 decades. His face was lined with age, his eyes sharp yet weary from years of hearing the same excuses, the same pleas, the same so-called defenses. He was known for his impatience, his biting sarcasm, and above all, his tendency to size up a defendant the moment they entered his courtroom. For some, that meant a firm but fair trial. For others, particularly those he viewed as unprepared or unworthy of his time, it meant humiliation before an inevitable conviction. And today, as he glanced over the docket, he was already prepared to deliver the latter. His lips curled in faint amusement as he read the next case. State vs. Malcolm Reeves. The smirk barely faded as he glanced toward the courtroom doors, waiting for the young man to enter. When Malcolm Reeves stepped into the courtroom, the energy shifted, though few realized it at first. Unlike most defendants who came through those doors, slouched and defeated, Malcolm walked with a measured, deliberate stride. His suit was modest but clean, his posture upright. There was no trace of panic in his expression, no darting glances in search of an attorney by his side. Because, of course, there wasn't one. He was his own attorney. A few people in the audience exchanged amused looks. Whispers spread quickly, "He's representing himself? This is going to be a disaster. This judge is going to eat him alive." Even the bailiff, a stone-faced man with years of experience, stole a quick glance at Judge Whitaker, anticipating his reaction. Malcolm ignored the murmurs. He had prepared for this moment more than anyone in that room could have imagined. A former bookstore employee, Malcolm had spent years educating himself in law, not because he had planned to practice it, but because he had always believed knowledge was the most powerful weapon a person could have. He never imagined he'd need it to save himself. The charges against him? Burglary. An accusation based on weak circumstantial evidence, the kind that often doomed men like him when they didn't have the means to afford a strong defense. But Malcolm had studied every statute, every precedent, every loophole. He knew the law inside and out. Now, he just had to prove it. Judge Whitaker leaned forward slightly, studying Malcolm the way a cat studies a mouse before pouncing. "So," he said, his voice carrying that familiar undertone of amusement. "Mr. Reeves, I see you've decided to waive your right to an attorney and represent yourself." Malcolm met his gaze evenly. "That's correct, Your Honor." The judge exhaled sharply, shaking his head. "Well, that's certainly bold," he chuckled dryly, looking toward the prosecutor. "Mr. Gallagher, I do believe this is a first for us." The prosecutor, a middle-aged man with slicked back hair and an easy arrogance, smirked as he adjusted his tie. "It's certainly rare, Your Honor. Though I can't say I'm too concerned." The audience laughed quietly, the tension in the room breaking slightly. To them, this was entertainment. A young man foolish enough to think he could outmaneuver a seasoned legal professional. Malcolm didn't flinch. He simply placed his briefcase on the defendant's table and calmly began arranging his notes. Judge Whitaker sighed, flipping through the file in front of him. "Let's just get through this quickly, shall we? Mr. Gallagher, proceed with opening arguments." As the prosecutor stood, full of confidence, Malcolm sat still, waiting. He had anticipated every argument that would be made against him. What he hadn't anticipated was just how much the judge would attempt to belittle him in the process. Judge Whitaker barely hid his amusement as the trial began. "Mr. Reeves, do you even have any formal legal training?" he asked, interrupting the proceedings before Malcolm even had a chance to respond to the prosecution. "I've spent years studying legal cases, statutes, and procedures," Malcolm responded smoothly. "I've also researched wrongful convictions, prosecutorial misconduct, and ineffective assistance of counsel." The judge chuckled. "So, Google and YouTube videos?" More laughter erupted from the audience. Malcolm's face remained impassive. "Law books, court records, and peer-reviewed legal texts, Your Honor." The smirk on Whitaker's face flickered, just for a moment, before he quickly masked it. "Well, Let's hope all that reading helps you today. Otherwise, this is going to be a very short trial. The prosecutor grinned, confident that Malcolm's so-called legal knowledge wouldn't hold up under real courtroom pressure. But Malcolm knew something they didn't. He wasn't here to play their game. He was here to change it. The prosecutor, Mr. Gallagher, rose from his chair with the confidence of a man who had already won. Adjusting his tie, he gave the jury a practiced smile before stepping toward the bench. "Ladies and gentlemen," he began, his voice smooth, authoritative. "The case before you today is not complex. It is not ambiguous. It is not a mystery." He turned toward Malcolm, sizing him up. The defendant, Malcolm Reeves, was caught on surveillance footage near the scene of a burglary just minutes before it occurred. He had no alibi. The stolen goods were found mere blocks from his home. And let's not ignore the fact that the store in question had been experiencing thefts for weeks, just as Mr. Reeves had been laid off from his previous job. Gallagher let the words linger. He was a master at crafting narratives that stuck in jurors' minds. He gestured toward the jury. "Now, some people may try to cloud the facts. They may attempt to twist logic, use fancy words, or even try to manipulate legal loopholes to avoid accountability. But when you strip away the distractions, you're left with this: the defendant was at the scene, had motive, and has no reasonable explanation for why the stolen items ended up so close to where he lives." He took a step back and spread his hands, as if the case had already been decided. "This trial isn't about emotion. It isn't about sympathy. It's about evidence. And today, the evidence speaks loud and clear: Malcolm Reeves is guilty." He turned and strode back to his seat, flashing Judge Whittaker a look of satisfaction before sitting down. All eyes turned to Malcolm. The moment had come. He rose slowly, adjusting his tie. The courtroom, still skeptical of him, waited for a stumbling, amateurish attempt at defense. Instead, his voice was steady, his words precise. "Ladies and gentlemen of the jury," he began, his tone calm yet firm. "Prosecutor Gallagher just told you this case is not complex, ambiguous, or a mystery. That's interesting, because as someone who has studied the law extensively, I can tell you that this case is, in fact, all three." A slight murmur rippled through the room. Judge Whittaker raised an eyebrow. Malcolm continued. "The prosecution claims this case is simple. But the law, true justice, is never simple. And when we examine the details, when we go beyond the surface of what's being presented to you, you'll see that nothing about this case is as open and shut as Mr. Gallagher wants you to believe." He turned slightly, locking eyes with the jury. "Because what happens when the so-called evidence isn't as strong as it seems? What happens when you find out the investigation itself was riddled with inconsistencies? And most importantly, what happens when the very foundation of this accusation starts to crack under scrutiny?" He let his words settle. "In the coming moments, I will show you the truth. And that truth will prove, beyond a shadow of a doubt, that I am not guilty." As Malcolm sat down, whispers spread throughout the courtroom. This wasn't the bumbling self-defense they had expected. Mr. Gallagher, slightly annoyed at the shift in energy, proceeded with calling his first witness, a police officer who had been part of the arrest. The officer, a middle-aged man with a badge gleaming under the fluorescent lights, took the stand. Gallagher approached. "Officer Jennings, can you confirm for the court where Mr. Reeves was when you apprehended him?" "Yes," Jennings said confidently. "He was walking down Parker Avenue, just a few blocks from the store that had been burglarized." Gallagher nodded. "And at the time of arrest, what reason did you have for detaining him?" The officer didn't hesitate. "We received a description that matched the defendant, young black male, medium build, dark clothing, near the scene. Given the time frame and proximity, we had reasonable suspicion to stop him." Malcolm leaned forward. Now was his moment. He stood. "Your Honor, may I cross-examine?" Judge Whittaker exhaled sharply, already annoyed. "Proceed." Malcolm approached the stand, hands in his pockets, calm. "Officer Jennings," he began, "you stated that I was detained based on a description given to the police. Could you read the description from the official report?" Jennings shifted slightly. Yes. The suspect was described as a young black male, medium build, wearing dark clothing." Malcolm nodded. "So, just to clarify, that description could fit hundreds of young black men in this city?" The officer hesitated. "Well, I suppose." "Right," Malcolm said. "And tell me, Officer Jennings, was there any other distinguishing feature listed? Any tattoos? Scars? Eye color? A specific article of clothing?" Jennings glanced at the prosecutor, then back at Malcolm. "No." Malcolm turned to the jury. "So the police arrested me, Without any physical evidence, based on a vague description that could apply to thousands of people? A murmur spread through the courtroom. Judge Whitaker's expression hardened. Gallagher stood quickly. Objection. He's twisting the facts, Malcolm turned. Am I? Or am I simply pointing out that the foundation of my arrest is fundamentally flawed? The judge banged his gavel. Keep it professional, Mr. Reeves. Malcolm smiled slightly. Of course, Your Honor. But the damage had been done. The jury was already shifting in their seats. And he wasn't finished yet. The next witness was the store owner, the man who had reported the burglary. Gallagher led him through a testimony painting Malcolm as the perfect suspect. But when it was Malcolm's turn to question him, the atmosphere changed. You mentioned that you saw the suspect flee the scene, Malcolm said. How far away were you? The store owner frowned. About 50 feet, I'd say. Malcolm tilted his head. At night? Yes. In the rain? The man hesitated. Yes. Malcolm nodded, then turned toward the jury. 50 feet away. At night. In the rain. And yet, you're certain it was me? The tension in the room thickened. Then Malcolm pulled out the police report. And, sir, in your statement, you originally said you thought the suspect looked like me. But after being shown my photo in custody, you confirmed it was me. The store owner shifted uncomfortably. I recognized him after thinking about it. Malcolm nodded, looking around the courtroom. Or is it possible that you were shown a photo and, whether intentionally or not, your memory was influenced? Another murmur. Gallagher stood. Objection. Leading the witness. Sustained, the judge grumbled. Move along, Mr. Reeves. But the shift had already happened. Doubt was creeping in. As the trial continued, Malcolm systematically dismantled every piece of so-called evidence. He pointed out the lack of forensic proof. He questioned the racial bias in how the case was handled. He cited legal precedents that even Gallagher wasn't prepared for. The judge's irritation grew. Mr. Reeves, do you plan on cross-examining every witness with these tactics? Malcolm met his gaze evenly. I plan on using the law, Your Honor. Whitaker clenched his jaw. Gallagher, once confident, was visibly frustrated. Every time he tried to dismiss Malcolm as unqualified, Malcolm responded with another fact, another statute, another precedent. The power in the room was shifting. The jury no longer looked at Malcolm as just another defendant. They were listening. And more importantly, they were believing him. The atmosphere in the courtroom shifts as the defendant, standing tall in the face of adversity, introduces a new piece of evidence. Not just any evidence, this is something that has the potential to unravel the entire case. A crucial document, overlooked in the prosecution's haste, is placed on the table. The judge leans in, squinting at the words. The prosecutor freezes. What exactly is this supposed to prove? The prosecutor scoffs, feigning confidence. The defendant smiles, calm and collected. He explains that this document, buried in stacks of irrelevant paperwork, contains an inconsistency that nullifies the main argument against him. It directly contradicts the testimony of a key witness. Gasps ripple through the courtroom. The prosecutor tries to dismiss it as insignificant, but the defendant is relentless. He points out that this mistake is not a minor detail, it's the foundation of the entire case against him. If this falls apart, so does everything else. The judge clears his throat, shifting uncomfortably in his chair. He's been in control of this trial from the start, but for the first time, it feels like the floor is slipping from beneath him. Murmurs spread like wildfire among the spectators. The public gallery, once convinced of the defendant's guilt, now stirs with uncertainty. Even the jury, once stiff and cold, exchange uncertain glances. The prosecutor is visibly rattled, flipping through his notes with shaking hands. He stammers, trying to formulate a response. He's been in this game long enough to know, if he can't turn this around, he's about to lose. But the defendant doesn't give him the chance. With the poise of a seasoned lawyer, he delivers his final argument. Ladies and gentlemen of the jury, from the very beginning, this case was built on assumptions. It was built on incomplete narratives and selective evidence. But today, you've seen the truth. And the truth cannot be ignored. The words ring through the courtroom with undeniable power. The prosecutor tries one last desperate attack, attempting to discredit the defendant, but it's too late. The damage is done. The momentum has shifted. A long, tense silence follows. The judge, who once saw the defendant as nothing more than a fool trying to play lawyer, now regards him with a different expression. He's no longer dismissive. No longer smug. There's something else in his eyes now. Respect. He straightens in his seat, exhales sharply, and looks at the prosecutor. The prosecutor doesn't say a word. He knows. The case is slipping through his fingers. And as the weight of everything finally settles in the room, the judge leans forward and says, "I think we've heard enough." The jury re-enters the courtroom, their expressions unreadable. The room is deathly silent, every eye locked onto the foreperson as they stand. The air is thick with anticipation, nerves fraying at the edges. Has the jury reached a verdict? The judge asks, his voice measured, but carrying a weight it lacked before. "We have, Your Honor." The defendant remains steady, hands clasped before him. He has fought tooth and nail for this moment. Not just for himself, but for the truth. The foreperson clears their throat. On the charge of, a pause, then, not guilty. The words seem to echo, bouncing off the courtroom walls. For a split second, there is only stunned silence. Then the courtroom erupts. Gasps, whispers, murmurs of disbelief, followed by applause from those who had doubted him. Some spectators shake their heads in quiet admiration, while others sit frozen, processing what just happened. The prosecutor exhales sharply, defeated. He knew the case was lost the moment the defendant dismantled his arguments piece by piece. There's nothing left to say. The judge calls for order, but there's something different in his tone. Gone is the dismissive, condescending air he had carried at the start of the trial. In its place is something more complex, perhaps even regret. The defendant does not smile, does not gloat. He simply closes his eyes for a moment, absorbing the weight of the victory. A fight well fought. A battle won, not just in the legal sense, but in proving something much greater. As the murmurs fade, the judge clears his throat. He peers down at the defendant, his gaze unreadable. "Before we adjourn," he says, his voice lower, more contemplative than before, "I have something to say." The room stills. This is unexpected. When this trial began, I made an assumption. Not based on the facts of this case, but based on something far less justifiable. The courtroom holds its breath. I underestimated you. A ripple of shock moves through the audience. Even the bailiff, usually expressionless, raises an eyebrow. The judge exhales, glancing at the prosecutor before returning his gaze to the defendant. "I have spent decades in this courtroom, seen hundreds, maybe thousands of cases. But today, I witnessed something that humbled me. You didn't just defend yourself, you upheld the very principles this court is supposed to stand for." The words carry weight, not just because of who is saying them, but because of what they mean. A man once dismissed as incompetent, ridiculed for daring to represent himself, has forced even the highest authority in the room to acknowledge his brilliance. The judge leans forward slightly. "I don't say this often, but," he pauses, as if struggling with the words, "you have a rare mind. And this court is better for having witnessed it." The defendant, ever composed, tilts his head slightly. "With all due respect, Your Honor," he says, "I didn't do anything that the law didn't already allow me to do. I just made sure it was applied fairly." There's no malice in his voice. No smugness. Just a simple statement of fact. The judge nods, seemingly satisfied with the response. "Well," he says, sitting back, "you did it better than most lawyers I've seen." With that, he bangs the gavel. Court is adjourned. The courtroom empties, but the case lingers in everyone's minds. Lawyers, law students, and reporters murmur about it in the halls, dissecting every moment. Some call it a landmark moment, a testament to what's possible when intelligence meets determination. News outlets pick up the story. Headlines buzz with phrases like "self-taught legal genius stunts court" and "unlikely hero redefines justice in landmark trial." Law schools reach out, offering full scholarships. Prestigious firms whisper about potential internships. Civil rights groups extend invitations for him to speak. But the defendant, standing outside the courthouse, remains thoughtful. The victory was his, but the fight isn't over, not just for himself, but for others like him. When asked by a reporter what's next, he simply says, "Today wasn't just about me. It was about proving that knowledge is power. And I intend to keep proving that, one case at a time." The message lingers, resonating far beyond the walls of the courthouse. Because this case wasn't just about one man's innocence. It was about dismantling assumptions. About challenging the status quo. About proving that intelligence and preparation can overcome prejudice. And as the doors of the courthouse close behind him, the world knows, this is only the beginning. The case that once seemed like an afterthought, a footnote in a system that often favored the powerful, became something far greater. Law professors dissected it in classrooms. Legal analysts debated its implications on television. The verdict was more than just a victory for one man, it was a wake-up call for the justice system itself. Inspired by his courage and intellect, others who had once felt powerless began to reconsider their own battles. Young law students from marginalized backgrounds saw his story and realized that they, too, could challenge the system. A wave of legal self-education spread through communities where good legal counsel was often out of reach. Organizations dedicated to legal aid reached out to him, eager to collaborate. Judges, prosecutors, and defenders alike began re-evaluating their biases, however quietly. The man who once stood in that courtroom, underestimated and alone, is alone no longer. Offers poured in, law schools, prestigious firms, advocacy groups. But he chose his own path. Instead of taking the highest-paying job, he started something of his own, an organization dedicated to helping those who, like him, had been thrown into the system without a fighting chance. A movement of empowerment, of knowledge as the ultimate weapon. He teaches workshops on legal rights. He mentors young people facing charges. He helps those who can't afford lawyers learn how to advocate for themselves. And every now and then, he walks back into a courtroom, not as a defendant, but as a force to be reckoned with. A courtroom is a place where narratives are shaped, where power is often assumed rather than earned. But this case, his case, proved that assumptions can be broken, that power can be challenged, and that intelligence has no uniform, no pedigree, no required permission. Never judge a book by its cover. Because sometimes, the person you underestimate is the one who rewrites the story.